Hello, I'm Robin Zellers with Fringe Benefit Analyst, your benefit guru. So today I want to review HIPAA privacy for non-medical employers. This video will review some HIPAA privacy basics that employers need to know.
Many organizations that fit the description of non-medical employers have employees by nature of their roles in human resources, benefits, or administration that have access to the private and personal health information, or PHI, of other employees. These organizations are legally obligated to protect information as described by the HIPAA privacy rule. The information here is intended to help employers determine what PHI is and which type of approach of PHI they should take. Nothing shall be construed as professional advice on any situation or a legal opinion. Keeping stored information about your employees secure is even more important than ever. You've probably heard about all the data breaches for Adobe, eBay, Equifax, and LinkedIn. While health records, ID numbers, and PHI are even more valuable on the black market than credit card numbers, you probably wouldn't want information about you to be available to anyone. Your employees feel the same. So what is PHI? It stands for Protected Health Information, which is individually identifiable information regarding an individual's record, payment, or application of physical health or a mental condition. Some examples are health and medical records, as well as personal information. This information may be used in your company for analysis, application of benefits, employment and hiring, examination of employees, or sharing utilization. PHI is regulated under Hipaa, the Health Insurance Portability and Accountability Act. Employers cannot disclose this information except for specific circumstances. You may need the information to administer your health plan or for internal process and analysis. If an employee discloses PHI without consent or uses it for personal gain, the penalties can be significant. Using PHI for personal gain could put you in jail. What is not PHI? Well, de-identified health information, which is stripped of identifiable information, employment records, and educational records. The HIPAA privacy rules do not apply to information that does not move through a health plan. Pre-employment screens, sick leave request, FMLA request, and return to work notes are not directly subject to HIPAA. Employers are advised to safeguard all information as confidential, and access should be restricted. Other laws may apply to these situations. Please discuss any specific information with your legal counsel. Who must comply with HIPAA? A covered entity. The rules apply to healthcare providers, clearinghouses, and healthcare plans. Employers that sponsor health insurance are responsible for their plan's compliance with the rules. Business associates. The rules apply to third parties or subcontractors that perform services on behalf of the employer, such as plan administrators, wellness programs, legal or financial providers, and brokers and consultants. An employer should have a business associate agreement with these providers. The minimum necessary rule states that only the minimum information needed to perform the task should be shared. Organizations that are subject to the HIPAA privacy rule are required to request, use, and disclose only the minimum health information that is necessary to support the purpose. Within the same organization, different departments may not have access to the same information due to the minimum necessary rule. Disclosure of PHI is only allowed without authorization when requested by Health and Human Services. Authorization is permitted but not required for treatment or payment, or when required by law. An individual must be given an opportunity to agree or object to specific use and disclosure. Requirements are very specific. Please seek additional advice about authorizations to disclose PHI. Privacy notice. Health plans are required to distribute a notice of privacy practices to all plan participants, including covered employees and COBRA participants. This document will explain use and disclosure practices and the individual's right. The plan administrator, generally the employer that sponsors the plan, is responsible for the notice and its distribution. Here at Fringe Benefit Analyst, we help you a step further by providing this notice to you every year at open enrollment for distribution at that time and to all new hire employees. Let me know if you need another copy of your privacy notice. Now that you understand the basics of what PHI is, let's explore some different types of PHI use for employers. Insured hands-off approach. This employer is insured but does not create or store PHI except for enrollment and health summary information that does not contain individual information. This category contains the majority of fully insured employer groups. Make sure you do not assist employees with claims issues and avoid creating or storing PHI. Also, do not send or receive enrollment data electronically. Insured hands-on approach. The employer is insured and creates, receives, or stores PHI about the plan and enrollees that contain identifiable information. Examples: managing a carve-out plan, self-administration of a cafeteria plan, wellness activities, assisting with claim issues, electronic enrollment data. These employers must comply with numerous rules. Self-funded hands-on approach. All self-funded plans are assumed to have access to PHI, as this is the nature of self-funded plans. This employer has the highest expectation of Hipaa privacy and should develop a secure plan and have a privacy officer. What if you do have PHI? It's very important that you develop a plan. Only give those employees in your organization access to the minimum necessary information they require. Keep your PHI locked and secure. Keep a log of anyone that has access to the PHI. Consider having a privacy officer. Conduct regular audits to make sure PHI has been properly contained and accessed. Do you need more help? There are third parties who can help you with technical or legal options. Ask me today for the information.
Thanks for listening today. Check back often for new content on my blog at www.benefitguru.net.